This is Colin O'Keefe for LXPN TV. Last week, the Supreme Court agreed to rule on the definition of close in wage and hour case Sandifer v. U.S. Steel. Joining me to explain is Arthur Rooney, partner in Seyfarth Shaw's Chicago office and author on the Wage and Hour litigation blog. Arthur, first off, can you give us some background on the case? What is at issue here?
Really, what's at issue is what are close, the definition of close under the FLSA. The case involves about 800 plaintiffs who were employees or current and former employees at a U.S. steel plant in northern Indiana. And they claimed that they were entitled to be compensated for the time they spent changing into their work clothes at the beginning of the day and changing out of their work clothes at the end of the day, and really anything in between that time, such as waiting or walking from the locker room to their work sites. And U.S. Steel took the position, no, pursuant to the parties' collective bargaining agreement, we only have to pay you starting from when you actually arrive at your work site and not when you get to the locker room and start putting on your clothes or going to the locker room at the end of the day and taking off your clothes. So what the case ultimately turned on was what are close under the FLSA, because there's a section 2030 which creates an exclusion under the FLSA and states that time spent changing clothes is excluded from compensable time if it is treated as non-work time under a collective bargaining agreement. In the U.S. Steel case, the changing clothes was treated as non-work time under the parties' collective bargaining agreement. So the case really turned on what are close under the Act. The plaintiffs in the case pointed to a 2010 Department of Labor administrator's interpretation that concluded that protective gear, such as steel-toed boots, flame-resistant jackets and pants, which are what were issued in the Sandifer case, are not clothes. And therefore, they don't fall under 2030's exclusion, and you have to compensate for that time. As you indicated in the introduction, the Supreme Court granted cert on one of the issues just last week.
So in looking at this at the Supreme Court level, any idea which way this might go, and how impactful could it be?
In terms of the significance, the potential significance of the case will obviously have a significant impact on companies who rely on the exclusion, the 2030 exclusion. It's important to note that that's a pretty small class of employers and employees affected by 2030 on this. Now, don't get me wrong, it's very important to the industries like the steel and meat and poultry industry where they are relying on it. But in the grand scheme of things for employers, most employers aren't relying on the exclusion. So I think the broader impact and potential impact of the case is what effect or what level of deference should be given to the Department of Labor when it issues these administrators' interpretations of the Act. Here, the Department of Labor in 2010 took a very narrow view in an administrator's interpretation of what the definition of close is under the FLSA. Well, but in the administration before, the department under the Bush administration took a much broader view of what the definition of close is. And then under the Clinton administration, it was a narrower view. The Supreme Court not only is going to look at how 2030 is defined, but it's also going to look at what level of deference or how much weight should we give to the Department of Labor when it's issuing these administrators' interpretations or opinion letters. And my guess is, just like the court refused to give the Department of Labor's interpretations articulated through amicus briefs any deference in Christopher v. Smith-Kline, I doubt the court's going to, there's any reason to give them any more deference in the context of administrators' interpretations. And if that's the case, that's not just going to affect the Sandifer v. U.S. Steel case and Section 2030, but it's going to have a much broader impact because the Department of Labor especially in the last few years, has been much more aggressive in issuing interpretations, whether it's through these administrators' interpretations or through amicus briefs. It's going to, essentially, if the Supreme Court refuses to give them deference, it's going to deal a big blow to the Department of Labor's attempts to, provide this, essentially rulemaking through the administrators' interpretations or amicus programs.
Again, that was Arthur Rooney of the Wage and Hour Litigation blog. For more of his commentary on this case, be sure to visit wagehourlitigation.com. And of course, be sure to visit lxbn.com for more video interviews on LXBN TV and for curated commentary from the LexBlog Network's more than 8,000 lawyers. Thanks for joining us, Arthur.
Thank you.